Welcome to our education video on ending a tenancy. My name is Mark Fiddler and I will be talking to you through what we need to consider and what needs to occur to end a tenancy correctly. We will discuss the end of tenancy process, including the ways in which the Act provides for a tenancy to end, discuss the reasons to end a tenancy, and then look at what responsibilities the parties have in ending a tenancy. The RTA would like to advise that the information provided within this video is general advice only and is not legal advice. Please refer to the Residential Tenancies and Rooming Accommodation Act of 2008 or obtain your own legal advice. As you can see on the slide, there are a handful of steps that should be taken to properly end a tenancy. Notice needs to be provided. Now this could be a notice to leave, which is a Form 12, from the property manager or owner to the tenant, or a notice of intention to leave, the Form 13, from the tenant to the property manager or owner. Please check the required timeframes before issuing the notice and ensure the forms are filled out correctly and in full. We understand that tenancies don't always end by using a notice, and we will discuss other ways a tenancy can end on the upcoming slides. The tenant has a responsibility to leave the premises in the same condition it was at the start of the tenancy, fair wear and tear accepted, so they would be expected to clean and repair any damage before handing back vacant possession. The tenant should also return all keys and fill out an exit condition report. We'll recommend that the parties communicate and work together through the exit process and come to a decision on how the bond is going to be distributed. The Act prescribes 7 ways to end a tenancy. The 2 most common ways are either the managing party issuing a notice to leave or the tenant issuing a notice of intention to leave. Other ways the Act prescribes that a tenancy can end are mutual agreement, both parties agreeing to end the tenancy. A termination order from the tribunal. Now there is a list of reasons for either party to make an application to end a tenancy. Abandonment. This is where the tenant leaves without providing any notice or letting the managing party know. Mortgagee in possession. So the property owner's bank is wanting to take possession of the property back. And death of a sole tenant will also end a tenancy. Now remember, any notices must be in writing and timeframes apply for the issuing of these notices. And we'll look at these options in more detail over the next few slides. The list of reasons shown on the screen is not exhaustive, but are some of the more common reasons for ending a tenancy. A full list of reasons and the timeframes required to be provided is listed on page 2 of the Form 12 Notice to Leave, and we encourage you to use the RTA's resources to ensure that you're using the right reason and timeframe. If a tenant's in a fixed term agreement, you cannot use change of use, relative or owner moving in, or sale of a property to end an agreement early. You must provide the tenant with 2 months' notice, and the handover date on the notice must be the end date of the agreement or 2 months from the issue date, whichever is the later. What we are seeing and hearing is that if a fixed term agreement needs to be ended, most are being ended with the ground end of a fixed term agreement. A periodic tenancy can only be ended using any of the bottom 6 dot points, and it's important to be aware that if you do use any of either change of use, sale of property or owner, or relative moving in to end a tenancy, that you cannot re-tenant the premises for 6 months. And also remember that if you use any of the 3 just mentioned, or significant repairs or renovations, there are penalties for providing false or misleading information if those reasons are not used correctly. I would also remind managing parties that if you are looking to end a tenancy because of an unremedied breach of the agreement, different timeframes apply to ending depending on whether it was a breach for rent or a general breach. A tenant can end a fixed term agreement or a periodic agreement without grounds. Now please be aware that reletting costs may apply if a tenancy is ended early. Other reasons that a tenant may choose to end a tenancy are due to the property not being in good repair. Now the tenant needs to give notice within the first 7 days from when they occupy the premises. If a co-tenant passes away and it would be impractical for the remaining tenant to continue or would cause them hardship, then they can end the tenancy. Also, a representative of a deceased sole tenant can issue a notice and end the tenancy by providing 14 days notice. If the premises are primarily used to provide student accommodation and the tenant stops being a student as outlined in the Act, they can give notice of their intention to leave. This is called ending of entitlement to student accommodation. Now, likewise, the student accommodation provider can also give notice to a resident if they are no longer a student. If a managing party has failed to comply with a repair order or misrepresented the property, the tenant can issue a Form 13, Notice of Intention to Leave, and if they've issued a breach notice and the matter remains unremedied and it's serious enough to warrant ending the tenancy, the tenant again can issue the Form 13. Now again, this list is not exhaustive and we encourage tenants to check the Form 13 for a full list of reasons to end a tenancy and again use the RTA's resources to check correct timeframes that need to be provided. Outside of issuing a notice to leave or a notice of intention to leave, the Act, as we mentioned, also provides for the tenancy to end in the following ways. Mutual written agreement. Now, if the parties involved in the tenancy agree to end early, they can negotiate and set the terms on which they will do so. We encourage all the parties to ensure that the agreement clearly sets out the terms and is signed by all. A tribunal application. So either party can make an application to QCAT for a variety of reasons as listed in the Act. We encourage you to check our website for information around what reasons are available. Abandonment. So as mentioned earlier, if a tenant leaves without notice, then the property can be considered abandoned. A Form 15 must be issued and 7 days notice must be provided. Again, check the RTA website for a fact sheet on abandoned premises. In a situation where there's the death of a sole tenant, if the tenant passes away during a tenancy, then the managing party can issue a notice to leave to the tenant's representative, or the representative can issue a notice of intention to leave to the managing party, giving 14 days notice to end the tenancy. If no notice is issued, then the tenancy does end 1 month after the tenant's passing. And finally, mortgagee in possession. If the property owner's bank has reason to repossess the property, then they can issue the tenant with a Form 19 providing 2 months' notice. The tenant can leave at any time within this 2 months' notice period and the tenancy will end. Both parties will continue to have responsibilities in the notice period leading to the end of the tenancy. The terms and conditions of the tenancy agreement must continue to be met. This includes the payment of rent and the requirement to abide by the rules of entry. We encourage the parties to access the entry pages on our website to ensure that they're aware of the requirements about showing prospective tenants or purchasers when a notice to leave has been issued. We also remind managing parties that holding of open homes or on-site auctions can only be done with a tenant's permission. As I touched on, the tenant is required to pay rent up until the vacate date, and the managing parties are reminded of the requirements under the Act in relation to payments of rent and that those payments can only be applied to rent. Also, the rules around apportionment apply in regards to the final payment of rent. Tenants have a responsibility to return all keys, access cards, and to ensure that the premises is left clean, having regard to its condition at the start of the tenancy, fair, wear and tear accepted. So at the end of the tenancy, the tenant is to complete the exit condition report as outlined under Section 66 of the Residential Tenancies and Rooming Accommodation Act. They provide a copy of the report as soon as practicable after the agreement ends to the owner or manager, who then has 3 business days to complete the report and return a copy to the tenant's address. It's recommended to ensure that this report is completed thoroughly and time taken to ensure all areas inside and outside of the property are covered. The RTA recommends both the tenant and the property manager or owner take photos at the end as further evidence of the condition of the property. The exit report is compared to the entry report, which was completed at the start, and again, photos are great to attach to both entry and exit reports. The RTA has a video on our website regarding how to complete the entry report. An option to consider is to do the vacate inspection together. While this is not a requirement, it may be an opportunity to address any issues quickly and start a conversation around the bond refund. We encourage you to access the website for information about the refund process. Now, if the managing party has issued a notice to leave to the tenant in accordance with the legislative requirements and timeframes, and the tenant has not vacated by the expiry of the notice, the managing party will need to apply to QCAT for a warrant of possession. Any application needs to be made to the tribunal within 14 days of the expiration date of the notice and is considered an urgent application. QCAT is self-representative and they will be looking for evidence to support your application. So you may need to present records of tenancy paperwork, including agreements and any notices issued. I also suggest here that any agreement is made between the parties to allow a few extra days for the tenant to leave, that's beyond the end date of the notice, that your 14 days to apply to QCAT is still from the date on the notice, not 14 days from the extra time that you've agreed on. Just as a reminder, property managers and owners are required to keep records relating to the tenancy for 1 year after the tenancy ends. So this includes, as listed on the slide, a copy of the tenancy agreement, a copy of both the entry report and the exit report, and a copy of any rent receipts or rent payment record. So just to summarise, it is important to be aware of your rights and responsibilities under the Act and ensure you are ending the tenancy in accordance with the legislation. That is, you are ending using the right reasons, notices and timeframes. Remember that all parties must continue to meet their obligations to the last date of the tenancy, and the property must be left as near to as it was at the start, fair wear and tear accepted. An exit condition report should be filled out and compared to the entry report, and the parties should be discussing the bond, remembering that the quickest way to have the bond finalised is for an agreed refund to be submitted. As always, the RTA encourages communication between the parties throughout the tenancy. Continuous and meaningful communication gives everyone the best chance to end the tenancy seamlessly and on time. Thank you for listening to our information regarding ending your tenancy. Further information about what I have discussed is available on our website www.rta.qld.gov.au or through our other channels, including our YouTube videos and podcasts. Our friendly contact centre staff can also assist you with your tenancy or bond inquiries on 1300 366 311. To stay in touch and receive regular updates from the RTA, we encourage you to sign up for our monthly e-newsletter or follow us on LinkedIn using the details on the screen.